Vicarious liability means that one person is held legally responsible for the actions of another person, even if they were not directly involved in the harmful act, typically arising in situations where there is a special relationship between the two parties, like employer-employee, where the employer can be held liable for the negligent acts of their employee while acting within the scope of their job duties. Essentially, the master answers for the servant. Key points about vicarious liability. 1. Relationship is key. A recognized relationship, like employer-employee or principal-agent, is necessary for vicarious liability to apply. 2. Action within scope. The harmful act must have been committed by the employee or agent while acting within the scope of their employment or agency. And 3. No personal fault required. Even if the person held vicariously liable did not personally contribute to the harmful act, they can still be held responsible. Example: if a company employee causes a car accident while delivering goods for the company during work hours, the company could be held vicariously liable for the accident, even if they were not directly involved in the driving. Vicarious liability means that one person is held legally responsible for the actions of another person, even if they weren't directly involved in the harmful act, typically due to a special relationship between the two parties, like employer-employee, where the employer can be held liable for their employee's negligence while on the job, essentially, answering for someone else's actions. Key points about vicarious liability. Based on relationship. This liability arises from a relationship between the two parties, like a principal and agent, where the principal is responsible for the agent's actions. No personal fault required. The person held vicariously liable doesn't need to have been personally negligent to be held responsible. Respondeat Superior, doctrine. This legal principle, meaning, let the master answer, is often used to explain vicarious liability in employer-employee situations. Landmark cases. 1. Burlington Industries, Inc. vs. Ellerth. This U.S. Supreme Court case established that an employer can be vicariously liable for a hostile work environment created by a supervisor. 2. Mohamud vs. W.M. Morrison Supermarkets PLC. A UK case where a supermarket was held vicariously liable for an employee's racially abusive attack on a customer. And 3. Bayley v. Manchester, Sheffield and Lincolnshire Railway Company. A classic case where a railway company was held liable for a porter's mistake that injured a passenger, as the action occurred during the course of employment. Examples of vicarious liability. 1. Car accident by an employee. If a company employee causes a car accident while on a work-related delivery, the company could be held vicariously liable for the damages. 2. Workplace harassment. If a supervisor harasses a coworker, the employer can be held liable for the harassment. And 3. Negligent medical treatment by a hospital employee. If a doctor employed by a hospital makes a medical error that harms a patient, the hospital could be held vicariously liable.